In this segment of the website, the tutorial, I explain to you in detail what you're going to keep in bankruptcy, whether it's Chapter 7 or Chapter 13. As a preliminary matter, let me share something with you. In 99.9% of all consumer bankruptcies, you're not going to lose any of your assets. I don't know where that all came about, whether it's the banks and the credit card companies with their false representations on TV, or ignorant people. You'll sometimes, clients will sometimes come into me and they'll say, well, I talked to a friend of mine and he lost everything he had in bankruptcy. Well, if you have a friend like that, or a claimed friend that's telling you that, what you need to do is ask him for the case number. Where can you and I look that case up? Because I'll tell you something. What he's telling you isn't true. You're not going to lose your assets. I wouldn't be in business if I was going to expose people to the risk of losing their assets. My gosh. The reason that you're not going to lose your assets is because the way the bankruptcy code is structured. Within your bankruptcy petition, and I hope you go through the sample bankruptcy petition and I give it to you in even more detail, but one of the documents that you and I are going to fill out is called a statement of intention. And in that part of your bankruptcy, you are going to announce to the world what you're going to do with each of your secured loans. Your car loan, your home loan, or whatever kind of loan it is. Maybe it's a loan on a boat or a motorcycle or whatever. Well, you decide what's going to be done with that loan. If you want to keep that loan, then it's called a reaffirmation, and you'll reaffirm the debt. If you want to get rid of that loan, then you'll surrender the property and have done with it. But the choice is yours. It's not anyone else's. So you don't need to be concerned about losing your assets because it's a secured loan in bankruptcy. That's not the way it works. Let's assume that your lender doesn't want to reaffirm. Well, it's not up to him. That's your right under the bankruptcy law. So it's not a case like a personal injury lawsuit or a criminal trial where there's a winner and a loser. No. Whatever you want to keep with your secured loans, you're going to keep. That's your right under the bankruptcy law. The other document I want to show you by way of introduction is what's called the exemption list. Every one of your assets, your household goods, all the things that you have in your household and all your other property, we're going to claim a bankruptcy exemption on that. Well, we don't go through trial to prove up your right. Those are your rights, period. And if you'll go through the series, this part of the series on exemptions, you're going to learn that in detail. So don't be concerned about losing your assets, and don't listen to some fool that's giving you false information. I hope that you watch the videos. I hope you have confidence that everything I tell you in this series is true. This tutorial is based on the Bankruptcy Code. I have over a 30-year familiarity with the Bankruptcy Code. When you get done going through the videos again, I hope that you give me a call. If you live in one of the counties where your 341 meeting is held in either Springfield or Carthage, those are two meeting places that I regularly attend for clients. I'm not going to turn you over to some $50 stand-in lawyer. I'm going to represent you. You'll be protected all the way. And remember, again, as far as the bankruptcy process goes, you're probably never going to be in a courtroom. You're never even going to see the judge. You're going to go with me to a meeting in either Carthage or Springfield. You'll be in and out in about an hour, and the rest of it you and I do. So don't be concerned, and don't be listening to a bunch of crazy people. Thank you. I hope you enjoy the series, too.